House to Home, presented by RE/MAX Diamond Realty.
Alpha Day, everybody. It is Tuesday, so that means we are talking real estate here on House to Home. And for the second straight week, we bring in a very good friend of ours, someone whose expertise and genuinely positive attitude is going to really educate us on the topic of power of sale. So for all the way from Tamuning, super far away, about 6 miles from me. What can I say? From Security Title, Kim Anderson. Kim, welcome. It's so good to see you again.
Thank you very much for inviting me back.
Of course. And of course, Gina Campos is at her office at RE/MAX Diamond Realty Guam, and Liz is right in the middle of Tumon Bay. Liz, I am so jealous.
I'm on down.
Yeah, well, I would love to, but we'll all stay 6 feet apart. But one thing that hopefully we are all going to come together on is this whole topic of power of sale. And Kim, forgive me, but ignorantly assuming that this is something that a lot of people tend to either not put enough thought into, or maybe just completely misunderstand and get it wrong.
So what I did was, when I was rethinking this, I've kind of been bouncing off the walls, and I'm trying to pull this back to sort of a cohesive thought. So I wanted to start with the fact that a trust is an entity that owns property. It's a very versatile entity that can protect you from lawsuits or divorce, or it can be used to distribute property and to avoid probate. But for this discussion, to kind of keep it short and to focus on my concern, I just want to concentrate on one little thing, which is real estate.
Sure.
In every trust, there's a portion that's called with power, the powers of the trustees. And that, if Liz does her trust, or Jason, you do a trust, that's where you enumerate all the things that you want your trustee to be able to do. You can sell it, you can mortgage it, you can exchange it, you can do whatever you want with it. The trust document later on will talk about certain items that are restrictions about what you can or cannot do. You might put into your trust that your family beachfront property cannot be sold. That has to remain in the family. Or if you have farmland and you have one member of your family that's a Farmer Woostig, for example, you would want to leave your property, the farm property, to him, because you know he's going to make great use of it.
Mm-hmm. Gotta love that sweet corn.
I know. So I make a souffle out of that, but that's a different story. We can talk about that all day long. You also might say if you have rental property, it should be sold, and all of it will be distributed among the children. So I use those examples to show how the body of a trust determines the sources and uses of trust-owned property. So that's the trust. The issue that I'm kind of concerned about right now is that Guam law has two very short sections that deal with trust property that are not common in other jurisdictions in the US or elsewhere, and which severely restrict the ability of an owner to deal with their very own trust property and their real estate. Those two sections are on Title 21, dealing with real estate of the Guam Code annotated, and it is section 29168 and 9. And I'm going to paraphrase both of them. The first one, 68, says that if a deed transferring property into a trust, so the deed where Jason Solis owns the property and he transfers it into the Jason Solis Family Trust, if that deed says with power of sale, then Jason's trust has the right to sell the property. 69, section 69, paraphrased, says that if the deed where Jason deeds into his trust does not contain those four little words with power of sale, then Jason, and as trustee, does not have the right to sell the property. Simply put, when an owner deeds their property into the trust, if that document does not contain those words with power of sale, the trustee has no power to sell the property. The remedy for that missing power of sale language is you have to go to court to seek an order granting you the authority to sell, lease, or mortgage the property. This sort of court involvement is costly, both to the owner and in my opinion, it's a waste of judicial resources. Trusts have become very commonplace for everyday people to use as a tool to manage their property. Over the past few years, the real estate industry on Guam has seen countless people forced to seek judicial approval to sell or deal with their property because of the lack of the words "with power of sale." If an attorney drafting trust documents misses this small and unique Guam detail, a trust cannot sell their property. So basically where we are right now is I spoke with Vice Speaker Tina Munya Barnes, and she teamed up with Senator Jim Moylan, and they're addressing this issue. They have introduced Bill 36-93, which is an act to repeal the 68 and 69. So far, we have support of our title insurance underwriters, the Legislative Review Committee of the Guam Association of Realtors, and various members of the Guam Bankers Association, although we have not asked for or received a formal endorsement yet. So that's kind of where we are right now. It's a work in progress.
Yeah.
Liz and Gina, how much did... Oh.
Yeah, so what happens is usually if I'm making a sale, a family will come to me and will say, we're selling this, but it's in a trust. So what I've experienced is always the title company wants to see a copy of the trust document, because if it doesn't have the proper language, then my client will have to go to court and go through the process. Fortunately, most of the documents that we've had, have had the particular language that Kim was looking for with the right to sell, the power of sale, right, Kim? It has to have that verbiage. So fortunately, with the ones I was handling that were that trusts were involved, they were able to complete the sale. But it happened at the tail end where the escrow company wanted to see that. I remember that has happened a number of times, not realizing what they were looking for. So this is critical for people who do have trust. Fortunately, I just closed a transaction, and I was concerned myself because I was selling something through a trust. Fortunately, the language was there. Otherwise, it would have been a big problem. And then it would have halted everything and probably take another 2 to 3 months, right, to get that resolved.
Now, Kim, you said if that 4-word phrase like is missing from when the lawyer drafts the documents up, is that typically because the client was negligent as far as that, and the lawyer was like, well, this is what my client wanted, not truly understanding it? Or could it, because I don't think it's like, because lawyers here are very, very good, and they leave no stone unturned. Yeah.
This is so obscure. These two little portions are so obscure that our title insurance underwriters were not aware of them. Attorneys who have been doing this work more recently are very aware of it and make sure that they're done. But a lot of the real estate attorneys and trust attorneys that have done trusts 20, 30 years ago, 10 years ago, we're just not aware of it. None of us were aware of it. And the underwriters I've dealt with have said, "Are you kidding me?" So we really, it's kind of a gift to get rid of this, I think. The distinction here to remember is the trust itself outlines what you can do with the property. The trust says don't sell the beachfront, give the farmland to Farmer Wistig, and sell the rental property and give the proceeds to the kids. That's what the trust says. What I'm talking about is a law that says the deed from Jason into his trust, the deed that transfers the property, the condo that you bought when you were young, and you've just been renting it out and you want to transfer it into your trust. If it does not say with power of sale those words, then you cannot sell it. So it's the deed, not the actual trust.
Mhm.
And stateside people deal with trusts with their stateside attorneys, and the stateside attorney will mail a deed to Guam to record to transfer the title into the trust. They would be completely clueless about this obscure portion of the law.
Gina, is this an outright deal breaker, or is this just like a heck of a lot of paperwork and a lengthy process that could like delay a transaction?
It kind of depends on what the judge says.
Well, in my particular case, I actually had a transaction where everything was smooth sailing. We got to closing, and we knew from the very beginning that it was a trust. And this gentleman had an attorney prepare the trust for him. And there's two parts to putting a trust together. You put the trust together, and then you have to take all the properties that you currently own. And as Kim mentioned, then you've got to feed the trust. So you've got to take everything you own. You got to do the deed that says, hey, Gina Campos now is going to deed. I'm going to sign this document that says I'm putting what I have into my trust. And in this particular case, his attorney did the paperwork 20 years ago. We got to closing, and they reviewed the trust documents, right? It was reviewed, and everything was great until we got to the closing. And then it's like, hey, wait a minute, there's something wrong with that deed originally, which is what Kim is talking about. He had the right to sell, but because his deed did not have those words, we actually had to stop and go to court. And it took 8 months to get the judge to say, okay, you can sell your property. So, I mean, it's just, it's a nuisance, and it costs money. It wasn't free.
And I would say maybe eight months would be conservative these days with, we just went through a pandemic and caseloads are large, and, I mean, 8 months would be, hopefully on the lighter side.
Well, yeah, I mean, that's a different conversation too.
Okay, so Kim, in summary, because we got a couple minutes left, for people that find themselves like in this type of transactional limbo, for lack of a more appropriate term, what can be done either through title companies like yourself, through realtors like Liz and Gina, or with attorneys if they happen to be stuck like this?
Well, sometimes what we've been able to do is, Jason, if you've transferred your condo into your trust and it did not contain those words, you can do an amended deed transferring title to your trust. That's one way we've addressed it. The other way is if the person who deeded it to you into your trust is no longer around, can't be found, or is passed on, then that's not an option. So you kind of have to go to court. And as I mentioned last week, when you go into the court, first you have to get on the calendar. It is an ex parte action, so there's only one party. It's not like you're suing each other back and forth. But getting on the calendar, explaining it to the court, that's why I feel like this is sort of a waste of judicial resources. They have plenty of important things to do rather than, reading your trust and saying, well, your trust allows you to do this.
Well, unfortunately, I've been there and I've done that when it comes to probate.
Yeah, and this isn't the trust isn't a vehicle to avoid probate.
Okay, well, Liz will give you the final word.
The legislation that's in place addresses this issue, right, Kim? So the legislation that is currently being proposed should help resolve this problem. And of course, it will repeal it. And we support the legislation. And we just want the public to know that this is something that may affect those who have the trust, and to support the bill.
I did place a call to the speaker's office yesterday and just left a message to ask that it be put on the list for public hearing. So meanwhile, I'll be talking to realtors, bankers, attorneys, and anybody who will listen, and ask them to support this.
Well, I'll tell you what, meanwhile, I'm just going to say, when it comes to trust, for me, the only one I'm going to trust is the three of you when it comes to like managing my affairs, when it comes to real estate, because I certainly cannot figure this out. So Kim, we appreciate it as always. So good to see you again. Liz and Gina, it's always a pleasure.
Thank you.
Yeah, ladies, thank you for the insight, and thank you out there for watching. We appreciate your visual patronage, and we will see you next time. Bye.
Thank you.